name is Chuong, managing partner of Legends. I focus on the commercial litigation and employment law. So today is because I only have 15 minutes, so I would like to present some key and critical issues related to the labor contract in Vietnam. Most of you are the foreigners. So the first thing I would like to present is the work permit. Before you enter into any contract or probation contract with any employer, the first requirement, you must have a work permit, and the employer has the obligation to apply the work permit for you. That's the first thing. And in my experience, some employer ask me that whether they can sign a service agreement with you instead of the labor contract with you. I can answer you now, cannot. Because service agreement is in the nature, based on, I have many cases at a cost. Some employers, they sign a service agreement with individuals, for example, and this is a practice in Vietnam. Many companies sign a service agreement with individual, and they only deduct about 10% of the personal income tax and pay to the government. After they finish the contract or finish the job, and they leave, and the service agreement is terminated. But it's lawful. The law does not allow to do that. But in practice, because many companies to do that, so and because they are the employees does not file official record, so they are not aware of the risk in signing the service agreement. The correct contract is the labor contract. Remember that. And furthermore, the labor contracts, the labor law of Vietnam is very favorable and very protective to the employees. The reason is the labor law is very protective to the employees because most of the employees in Vietnam, particularly the Vietnamese employees, are the blue-collar workers. They work in the factories, and the Communist Party is the party for the farmers and workers. So when they issue the law must be protected to the farmers and the workers. So that's the reason why when signing a contract with an employee in Vietnam is easy. But if you would like to unilaterally terminate the labor contract with them, it's very difficult. The next is the types of the labor contracts. There are around three types of labor contract. The first type is the seasonal labor contract, and the labor contract with a short term below 12 months. The second type is the definite term labor contract, have the term from the 12 months to the 36 months terms. And finally, the third contract is the indefinite term of labor contract. When the law is only allowed to sign the definite term labor contract only 2 times, and the maximum of each definite term labor contract is the 3 years, the maximum. If you sign the definite term labor contract with 1 or 2 years, you are allowed to extend 1 time. But the total times of the labor contract already signed and the extension is not over 3 years. And the employee, during performance of the labor contract, the employees can easily unilaterally terminate the labor contract with the employer for some simple reasons. For example, the family reasons, and they want to change the jobs due to the economic reasons. But in return, the employee if the employer would like to terminate the labor contract with employees, it's very difficult. The reason the law, although even in the labor contract you mention about the case, you are allowed to terminate the labor contract to the employee, but the reasons must inconsistent and in accordance to the law. Otherwise, the reason or the agreements you provided in the labor contract is invalid. And under the law, there are the 4 reasons. Only 4 reasons. In case of you would like to unilaterally terminate the labor contract with employees. The first is if the employee regularly fails to perform his jobs or duty under the labor contract. The second reason is that if the employee is sick or have accidents or force majeure case. In the force majeure case, the employer are allowed to terminate the labor contract with employees. And the last reason is that if the employee absent from the work around 15 days from the expiry date of the suspension of the labor contract, with these four reasons to unilaterally terminate the labor contract with employees, only the first reason may be possible. But how to prove that the employee regularly fails to perform his duty or his jobs under the contract? You need the evidence. And most of employers in Vietnam, when see that his employee lazy or fail to perform his duty or jobs under the contract, so the employer would like to terminate the contract with them or dismiss the employee. But they don't have enough evidence to prove that, so that's a mistake. And when the unilateral termination to the labor contract is unlawful and the employee file a lawsuit at court, the employer has to re-employ or reinstate the employee and make, I think that's much compensation to the employee. That's the case about the unilaterally terminate the labor contract. And another case is the dismissal. Dismissal is also the way to terminate the labor contract with employee. But dismissal, if you would like to dismiss an employee under the labor contract, is not based on the reason in the labor contract. You must have the internal labor regulation, which is lawfully registered with the labor authorities. If the violation of employees is not stay in the internal labor regulation, you cannot dismiss or you cannot discipline the employee. Even you know that, for example, you know that there is a guy make something wrong in your company, but his violation is not provided in the internal labor regulation. So you cannot dismiss him, or you cannot apply any discipline against him, for example, the warning or demotion. The next is about the severance allowance, insurance and allowance. For the expat in Vietnam, for the Vietnamese employees, when they enter into the labor contract, the employer and the employee will jointly to participate in the social insurance, medical insurance, and unemployment insurance. For the expat, they only required to participate in the medical insurance only, not unemployment insurance. So when the employer would like to, when the labor contract between an expat and a company is terminated, an expat should remember to claim the severance allowance. Because if you don't claim the severance allowance, you will lose the right after the 12 months from the date the contract is terminated. We have any lawsuit relating to this matter. But when we file the lawsuit at the court, because say that, hey, the time limit is passed, so you cannot claim anymore. And the severance allowance is if you're working for employer in 1 year, you are entitled to the 0.5 months salary. The employer also reason that because you are an expat, you have all benefits much better than the local employees. But the employer doesn't know, and the employer assumes that there's the benefit. The additional benefit and bonus to you at the beginning you sign the contract with the employer is a kind of severance allowance. It's not like that. Under the law, severance allowance only arises when the contract is terminated only. Even regardless of what kind of benefits or what kind of agreement you agree with the employees at the beginning, but such kind of benefit cannot consider as the severance allowance. Severance allowance is a legal obligation of employer when the contract is terminated. And about And in scale, you would like about a contract. Another very important things. I think that's because the law, the labor law of Vietnam is very protective to employees, but it's not protective to employer. So one of the most important problems is the conflict of interest. When an employee, the Vietnamese law allow an employee to have the two jobs or more than one job at the same time, with the condition that the employee can ensure the working time committed with the current employer. So this will fall into the conflict of interest. And in the Vietnamese labor law and all the law as well, there is no clear definition about conflict of interest, particularly for some of the technology companies. The conflict of interest is very important problem. And the confidential obligation as well. How's the Vietnamese labor law doesn't provide the definition of how what is the confidential information. If the in the agreement, in the labor contract, you may provide about the confidential information, the definition about the confidential information. But when come to the dispute at the court, the court said that there is no definition under the law. So they cannot pass on the agreement between both parties to consider the information the employee knows about the company is the confidential information that is provided in the labor contract. And another thing is about the competing after leaving the company, non-competing after leaving the company, because some Vietnamese law does not recognize that.